about Nnamdi Kanu's appearance in court, expected again later today. And joining us to talk on it is constitutional lawyer and public affairs analyst, Barrister C.C. Chukwudi. Barrister Chukwudi, welcome back to Breakfast Central. Good morning to you. We knew before now that this hearing was set for 19th of January and 20th next year. So what does the abridgment of time mean then now?
Good morning to you, and I am pleased to be part of the program this morning. Let me start by saying that the abridgment of time is a judicial process whereby the already agreed time it's reduced, brought back a bit based on the exigencies required in the matter. It is mostly applicable where fundamental rights are applicable or the rights and liberties of persons are applicable. And it's also applicable in the state of emergency whereby exigencies are required. We have noted that, like I said in my previous interview, that in criminal jurisdictions, matters are handled.
All right, so I suppose we still have Barrister Chukwudi with us right here on Breakfast Central as we're looking into the issue about Nnamdi. All right, Barrister Chukwudi, go on.
Are we together? I said that matters of criminal proceedings requires much exigencies and expedient trial. So it means that anybody who is facing criminal trial, the law enshrines that he must be given not only trial but also expeditious trial, particularly when the person is still in custody, so as to know his fate, his liberty, and all other rights granted to him by virtue of Section 36 of our 1999 Constitution.
All right. Now, Barrister, there's been lots of tension around this particular situation with numerous calls on Mr. President to wade in and release Kanu. Do you think this in any way necessitated the hearing of today?
Can I please hear you?
Now, we're wondering, because a lot of people believe that the call on the president to release Nnamdi Kanu was what possibly necessitated the hearing that we're getting to know of that's happening today. Is that true? Barrister Chukwudi, can you hear us?
Yes, I am. Where with you, please?
All right. We're wondering, and we're trying to get confirmation, if the pressure on the president to wade in and release Nnamdi Kanu might be what has brought forth the hearing to today. Can you confirm this to us?
I would rather not confirm on that, but I may say that it was suggestive of that. We all know how the hearing on the last day was handled. It ended up.
All right, you're still watching Breakfast Central on News Central with Oluchi and Olisa that were looking ahead to Nnamdi Kanu's appearance in court yet again today with Barrister C.C. Chukwudi joining us. Barrister, good to still have you back. You can continue on your points.
Yes, what I'm saying in essence is this, that part of the events that played out on the last court day could also propel why the lawyers moved back to the Honorable Court. We know that before now, various motions, which include the motions challenging the jurisdiction of the court, the motions seeking for the release of Nnamdi Kanu, probably on bail, were all pending for hearing. And there were affidavits of urgency deposed and attached to that particular motion, seeking that he must be released and his trial must continue. So I believe that because the trial of the last date did not end up probably on a good note as expected, because his lawyer was not heard, his motion was not heard, and then the court adjourned up to 19th and 20th of January 2022. So I believe so that the lawyer went back to the court and filed a motion for the abridgment of the time. Because according to the lawyer, when I heard him say that those motions, we are seeking for expeditious trial and hearing of those motions. And we also know that thereafter, tension arose from all quarters, particularly the southeast, which compelled some members or stakeholders, elderly members who visited Buhari and sought for his release. So we are saying that what happened on the last day may have contributed why there was application to the court to abridge the time. The time of the court, when taken, cannot be reversed except by a leave and an application seeking for the abridgment of time. So you cannot say that Buhari or any other person from the presidency call the court and say, court, please bring back the time, bring back the date already agreed on record. But it was consequent on a motion filed before the Honorable Court seeking for that abridgment of the time. And part of the reasons would be contained in the affidavit in support of that motion, which I believe would certainly answer on the expeditious hearing of the motions already before the Honorable Court. Right. And like I told you, that abridgment of the time is consequent on the doctrine of expeditious hearing of criminal matters.
All right, Bryce Chikudi, just before we let you go, now the Attorney General of the Federation, Abubakar Malami, now he's described the calls for pardoning Nnamdi Kanu as premature. What does this tell you about this matter then going forward? I
don't understand you. He said that the call of what?
The call to have him pardoned and released. That the Justice Abubakar Malami has described the calls to pardon Nnamdi Kanu as premature.
Let me say quickly that our Constitution provides, particularly Section 36 of 1999 Constitution and Section 35, makes provisions on how people who are alleged to have committed offense can be pardoned, can be granted amnesty, and can be forgiven. You see, all these things have their own implication and legal implication. When a person is pardoned, it means that he has been tried and convicted, and the court pardons him. And the president pardons him. He has been pronounced guilty. When he is granted amnesty, amnesty is that he has been committed an offense, but has not been convicted. So he will be granted amnesty. He says, "Go and sin no more." We don't want to try and convict you. You have already accepted that you committed the offense, but we don't want you to go through the processes of conviction. But please don't do any more. That's an amnesty. Then all these things have a procedure. Now, when a person is being tried, the president can stop the proceeding by entering what is called nolle prosequi. That is to say, the Attorney General by himself will approach the Honorable Court and say, no, we don't want to continue the prosecution of this person because of the interest of the society. That is how the law provides for it. When you look at Section 211, Section 1.
All right. Well, thank you so much, Barrister C.C. Chikudi, the constitutional lawyer and public affairs analyst, for coming on Breakfast Central.